entry, etc., into places of public worship is specifically dealt with only, if at all, by any legislation that can be made pursuant to Article 25(2)(b). We can't invoke general provisions of 15, 16, and various other provisions. And my Lord knows, Article 29 and 30 also do not talk about gender or sex, because we have in our history had institutions exclusively for girls, exclusively for boys. There are today a large number of co-educational institutions, but nobody wanted to make it mandatory to enable Parliament or legislature to make laws which will make it compulsory that it should be co-educational institutions. Therefore, that part was kept out. I'm just giving an analogy. Now, if my lords will kindly go to para 26. It is submitted that access to public use of a secular nature is guaranteed under Article 15(2) on all counts: religion, race, caste, sex, place of birth. Article 15(3) and 4 secure educational empowerment for scheduled castes and scheduled tribes. Article 16(1) guarantees equality in matters of employment under the state, while Article 16(4), 4A and 4B secures social and economic empowerment of scheduled castes and tribes by enabling reservation. Article 330 and 332 secure political empowerment to scheduled castes and tribes by providing for reservation of seats in the House of People and Legislative Assembly. Therefore, on the secular side, justice, social, economic, and political, and equality of status and opportunity is guaranteed to all by various persons, and including scheduled castes and tribes. 335 ensures that claims of SC/ST members are taken into consideration. But otherwise, Article 17 deals with untouchability, specifically in the context of the past unfortunate historical practices. And that's why my lords in Nagaraj, which I quoted in para 27, insofar as religious institutions are concerned, social justice and equality is guaranteed. Hindu religious institutions of a public character alone, and not institutions of other religions, or even private character, Hindu religious institutions of a private character, and in my respectful submission, even denominational character, if they do not throw it open. The reason is to give effect to the mandate of Article 17. And I have quoted Nagaraj, great social injustice resulted from treating sections of Hindu community as untouchable. And therefore, Article 17 abolished untouchability. And 25 permitted the state to make any law providing for throwing open all public Hindu religious temples to untouchables. Therefore, it is in that context nothing to do with gender or sex. 25(2)(b) is a targeted social reform provision, not religious reform. I am going to deal with it in that separate note. I will come to that. Para 32, on untouchability. Now kindly come to para 33. The heading. Article 25(2)(b) is not a general equality provision. Constitutional power to throw open temples to all classes and sections of Hindus is not a facet of general right. Sorry, 33, para 33, and the heading above that, F. Article 25(2)(b) is not a general equality provision. The constitutional power to throw open temple to all classes and sections of Hindus is not a facet of general right to gender equality. The provision was introduced as a specific response to caste-based exclusion rooted in untouchability and must be understood within that limited constitutional context. The fact that the framers of the Constitution specifically empowered the state to enact laws, throwing open Hindu religious institutions to all classes, public institutions, to all classes and sections of Hindus, is constitutionally significant. If the equality guarantees contained in Article 14 or 15(2) were themselves sufficient to mandate universal access to temples, 25(2)(b) would serve no independent purpose. It would have been odious. Therefore, we have to give meaning. Then, the next one, I want to this has been dealt with by the learned solicitor on religious denomination. Millard, I want to, my submission is going to be, Millard, in Shirur Mutt, when reference was made to the Oxford Dictionary, and Millard, 3 conditions were set out. This was not considered by the court in Shirur Mutt to be mandatory requirement. This was only an extract from the dictionary. Millard, the solicitor has already placed, and Millard, the learned additional solicitor also has placed, Millard, the authorized Hindi version about Dharmik Sampradaya. Millard, I'll deal with that. And Millard, if my lords will kindly see para 39 and 40, Millard, this is our respectful submission. The court did not lay down a rigid threefold test for identifying a religious denomination in Shirur Mutt. Besides, the court did not have the opportunity to refer to the authentic Hindi translation of the constitution, where the expression used is Dharmik Sampradaya. In the absence of that, they referred to the Oxford Dictionary, which was more concerned with the Abrahamic religions and not in the Hindu context. And unfortunately, in S.P. Mittal, when Sri Aurobindo Society was a petitioner, Sri Aurobindo Society was faced with a peculiar problem. This was during the emergency, particularly when Sri Naujata, who had become a kind of successor after the Sri Aurobindo and the mother, and he was heading the institution. He had unfortunately fallen out with some persons who were in power, who had, because in Auroville, lots of foreigners were there, and then they had access to the powers that be. And this led to enactment of law. And they had to challenge it and challenge the validity of the Auroville takeover. That was the historical background of S.P. Mittal. Where, though Sri Aurobindo never said he's espousing a new religion, his was essentially one of integral yoga, and then achieving that every person is capable of raising to the level of supramental consciousness. Effectively, Advaitic concept, because Tattvamasi, Aham Brahmasmi, therefore raising yourself to the level of supramental consciousness. That was basically the philosophy of Sri Aurobindo. And when they were faced with the kind of takeover, they had to raise pleas. And I had drafted the petition, so I'm somewhat familiar with this case. And Mr. Sorabji and Mr. Vanugopal had appeared. Mr. Sorabji argued the aspect about religion, and Mr. Vanugopal had argued about religious denomination. The court took the view, no, this is not separate religion. Now that problem was, they applied the tests of Abrahamic religion. They said it is only a philosophy. A philosophy is capable. What is our concept of understanding a religion? We never had anything like Hinduism as the term for our religion. It was Sanatana Dharma. That it is Hinduism is a concept of the colonial rulers in the last 2 centuries. Before that, it was never known as Hinduism. It was always Sanatana Dharma. Now, if we import all these tests in regard to Abrahamic religion and hold that Aurobindo's philosophy is not religion, that part was rejected. Then on the question of religious denomination, they said Shirur Mutt has referred to Oxford and set out the three conditions. The expression religious denomination must also satisfy three conditions. With the greatest respect, I appeal to my lords to kindly overrule this part of it. The test in regard to religious denomination, which has been laid down as if it is mandatory, I respectfully submit is incorrect. And the test adopted by Justice Chinnappa, kindly see the underlying portion which I have extracted in paragraph 41. Justice Chinnappa's dissenting view. We take care to mention here that whatever the ordinary features of a religious denomination may be considered to be, all are not of equal importance, and surely the common faith of the religious body is more important than the other features. And then Miller at the bottom of the page. Yes. It is perhaps necessary to say that judicial definitions are not statutory definitions. They are mere explanations, every word of which is not to be weighed in golden scale. Then Miller at the bottom of the page. Religious denomination has not to owe allegiance to any parent religion. Miller, this is very, very important because it is as if when we say religious denomination, it has to be of a particular religion. No, it is not necessary. It can either be a separate religion or it can be a denomination which is emanating from a particular religion, but it need not owe allegiance. Entire following of a religion may be no more than religious denomination. This may particularly be so in the case of small religious groups or developing religions, that is, religions in the formative stage. That is, when schism takes place. When in a religion schism takes place, a small groups takes a different view. It may not necessarily have the same common view. Now, Millard, I have referred thereafter in page 18, paragraph 44, to Sampradaya, and Millard, kindly read with me the definition given by Dr. Radhakrishnan and also Arnold Toynbee. Aboriginal tribes, savage and half-civilized people, the cultured Dravidians and the Vedikarians were all Hindus, as they were the sons of the same mother. The Hindu thinkers reckon with the striking fact that the men and women dwelling in India belong to different communities, worship different gods, and practice different rites. And Arnold Toynbee, in the present-day experiment in Western civilization, when we pass from the plane of social practice to the plane of intellectual outlook, Hinduism too comes out well by comparison with the religions and ideologies of the Southwest Asian group. In contrast to these, Hinduism has the same outlook as the pre-Christian and pre-Muslim religions and philosophies of the western half of the world. Like them, Hinduism takes it for granted that there is more than one valid approach to truth and to salvation, and that these different approaches are not only compatible with each other, but are complementary. That has been our dharma, while retaining an underlying and cultural, spiritual unity. The spread of distinct practices, practitioners, deities, rituals, and tradition across the subcontinent, therefore, reflect the inherent diversity of Hindu religious life. It is within this context that sampradayas emerge and should be understood. And Millard, I have extracted the Moni Williams Sanskrit-English dictionary. A traditional sampradaya means it can refer to the doctrine, it can refer to the sect. Because Millard, one of the things arising from the question that was raised this morning, Millard, therefore there can be changes in the doctrines, but it can lead to a schism or it can lead to a new sect. A traditional doctrine can handed down, a sect a particular system of religious teaching, traditional belief or usage, and Apte's Sanskrit English dictionary, a traditional doctrine or religious system transmitted through successive teachers, a sect or established religious tradition. Then will kindly come to para 47.
46 also the root.
Yes, 46 also. The word itself derives from the word root, sampradaya, meaning to hand down or transmit, signifying a body of religious teaching, ritual practice, and discipline preserved through tradition. The agamas themselves are defined to be revealed teachings which has come down. A sampradaya is the lineage which transmits the teaching. The concept of sampradaya is closely connected with the principle of Guru Parampara, that is, the transmission of spiritual knowledge, ritual practice, and theological doctrine through a recognized lineage of teachers and disciples. Classical Hindu tradition have historically preserved their theological identity through such lineages, ensuring continuity of doctrine, discipline, and ritual observance across generations. The preservation of a sampradaya therefore depends upon the ability of the community of the worshippers and its spiritual religious authorities to maintain the distinctive practices and modes of worship associated with that lineage. Now, this unfortunately is something which has been missed out in the Sabarimala case. Therefore, their identification of what is a religious denomination and whether, therefore, the devotees of Ayyappa constitute a religious denomination, unfortunately, has failed to apply what, according to me, will be the appropriate test in the Hindu context, in our milieu, in our tradition. It is well known that the organization of Hindu religious life has accordingly taken place through such sampradayas, each characterized by shared theological understanding, recognized ritual practices, and a community of adherents bound by a common discipline of worship. These traditions frequently develop around particular deities, pilgrimage centers, or spiritual teachers, and are sustained through continuous practice rather than through a centralized ecclesiastical structure. We don't have a system of a pope, archbishops, and bishops, and that kind of an ecclesiastical structure we don't have.
That means in Hinduism, the Hindus belong, there are Hindus who can belong to several sampradayas.
Yes.
But and they can visit any temple, there's no bar.
Yes.
But if the Hindus want to visit a particular temple, the sampradaya which is attached to that temple must be followed.
Yes, correct, exactly. I'm very, very grateful. Now, take the case of Ayyappa.
We are not, you see, we don't have that rigid system.
Yes, correct.
All Hindus are Hindus.
Yes. Interestingly, in Sabarimala, no distinction is made. There is no bar to Christians or Muslims entering. They can also go. But if they must have the faith and belief in the divinity of Ayyappa. Therefore, you have to follow the Vratam, the 40-day Vratam, and whatever are the practices enjoined on the believers, and they go and approach. Nobody is prohibited from that. Therefore, this concept, unfortunately, has not been understood. It is not necessary that religious denomination means that a person should belong to a particular religion and then it is a sub-branch of that. It's not necessary.
Sure, like that.
Therefore, that unfortunately has erroneous understanding.
You may belong to one sampradaya, may follow one mutt. Nothing prevents you from going to another mutt or going to a temple which belongs to another sampradaya, but you must respect that.
Correct, exactly. In the Kashi Vishwanath case again,
differently. One does not have any choice except to go under the Sampradaya, which is either attached to the temple or in a denomination. Because the moment you start questioning it, you go out of the denomination.
Correct. Exactly. Then you are no longer in the Sampradaya.
Putting it
You are a non-believer.
It's not even a question of laying a challenge because you are not part of the Sampradaya.
Yeah.
If you are not of the part of Sampradaya, nothing to do with your personal belief. You can have your own personal belief.
Correct.
But you can't try to change the belief.
Yeah.
Whether you go under it or leave it.
Correct. Under Article 25, you might have your individual belief, you are entitled.
That is protected, subject to the restriction given under 25.
Correct. But if you want
Yes.
to go to a temple or an institution belonging to a particular sampradaya, then you must believe in that sampradaya. You must be part of that sampradaya. Follow the practices of
For
the
example,
sampradaya.
Kerala, in North India, some temples, you have to wear dhoti. You can't wear shirt. Can't just go there. If you want to go, you can't say I am entitled to wear shirt.
Correct.
If you want to do this, you do that. So,
I think same example as my brother is giving.
Wear dhoti.
In some of the
Is
temples,
that
like
part of the...
Convenience sake, on pants they put dhoti.
Outside the temple, Millard,
Sir.
you have dhoti and you can...
There is some substantial compliance.
That's right, Millard. It's not actual compliance, but substantial.
like Guru Vayu temple, you can't wear the shirt.
Yes.
You have to remove the shirt
That's right.
when you want to go
That's
to
right.
Guru Vayu
When you
temple.
go to a.
In North India, when you go to Gurudwara Sahib,
Gurudwara.
Yes.
Golden Temple or any other Gurudwara, you have to wear the.
Yeah, correct. Millard, even in Vaishno Devi, if you are going for the aarti, you have to cover up your head.
Millions of Hindus go in the Gurudwara, but they will have to.
Yes, we have to
maintain
cover.
the decorum.
Golden temple, we have to cover our head.
Yes.
Mr. Vaidyathan, all these examples actually show the precedence of 26 clause B with regard to its superiority in the managerial rights of religious affairs, which are manifested through these expressions of ritual, practice, etc., over the core internal belief, which is freedom of conscience and its rights of professing, practicing
Yeah.
of religion. So a person who is a non-believer, even if he goes to a temple or a mutt or any institution managed by a denomination or a section of denomination, has to adhere to the
Correct.
Yes.
religious affairs manifested through the rules.
Correct. That's right.
This is what you are.
Yes, that's my son.
And in this respect, the real conflict is the propagation of the non-believer of his right becoming eclipsed for that temporary period where he submits himself to the domain of the management of the affairs of the religious denomination.
Millard, that person's
That does not mean that the visitor gives up his freedom of conscience not to accept it, but has to subject to it.
correct.
Because if we hold otherwise, that the non-believer cannot interface, then we would be eroding the non-believer of his core freedom of conscience, even to profess. Because to profess, if you look from the contrarian view, a person who has to contradict a proposition must experience the proposition. So in
Correct.
doing that, the non-believer may subject himself, but need not accept the religious practices.
Correct. Millard, individual's freedom of conscience under Article 25
Exactly.
cannot defeat the freedom of the community or the denomination.
It's a more
And-
core esoteric thought.
So
That's
now,
right.
by virtue of this,
Yes.
you admit that Article 26 is not an island provision or island article or a standalone article.
Millard, Article 26B is, Millard, I have a submission on that. Millard, Article 26B is the right of the denomination in regard to religious practice, affairs of religion. Millard, question is not whether it is an island provision, whether it can be controlled by 25(2)B. 25(2)A and 25(2)B. Millard,
So the
if
reason
my
for
lord will...
purpose, if you
Yes.
say 26B is an island provision or a standalone,
Millard,
that means you will
Millard,
canvassing, it is not governed by 25(2)B by virtue of You go out of part 3 of the Constitution.
25 and 26 come under the heading right to freedom of religion. Therefore, it is not in that sense an island provision. But can the right under Article 26B, that is, right of a denomination to manage its own affairs in matters of religion, be subjected to any law made pursuant to Article 25(2)B is perhaps the prime question which I have to address. I have dealt with it in a separate note. My respectful submission is it can't be. Shirur Mutt was concerned with 25(2)A. 25(2)A because it was the question therefore asked in Shirur Mutt was the submission of the Attorney General, which is recorded at page 173 and 180, was, is this a secular aspect which can be regulated under 25(2)A, or is it something to do with religion which can't be regulated under 25(2)A? That was the only limited aspect canvassed before the 7-judge bench. Now, Millard, there are
Scale of expenditure, the scale of expenditure
yes.
for the purpose of an activity associated with religion but not
Correct. Therefore, which was regulating or restricting any economic, financial, political, or other secular activity. That was the question. That was the secular activity. Now, Millard.
In other words, you admit 25(2) has to be read along with 26.
No, I don't.
The reason,
Millard, because
there is a reason, because
correct.
Union of India has canvassed.
Yes,
That
Millard, I am, yes, I agree, Millard. Therefore, I said I digress from that view.
so we wanted to know.
Yes, Millard.
You are in disagreement with that view of.
Yes, I am in disagreement with it.
Vaidyathan is putting 26(2) at a higher pedestal
Yes, Millard.
than 25(2) because
25(2) is only an enabling power. 25(2) does not confer any right. It confers a power on the parliament or the legislature to make a law. 25(2). Therefore, now we are comparing one provision which gives an enabling power. 26 is a right which has been given. There is no comparison between the two. 26 has to prevail. 25(2) cannot. 25(2).
Venkatramana Devaru, both the provisions were considered. Venkatramana Devaru.
Venkatramana Devaru, in my respectful submission, has unfortunately laid down an incorrect law which needs to be overruled. We had to give.
We accept this proposition.
Yes.
This 26 is to be construed virtually in exclusion to 25(2). Then that means tomorrow there will be a situation where others will start asserting and say you will exclude X, Y, Z. You cannot.
With the greatest respect.
Part 3 steps in.
With great respect. With great respect. There can be temples. There can be private, there can be temples which are not public temples, denominational temples, which can exclude. I'm sorry?
Very high.
I think, Mr. Vaidyathan, first you complete your argument because probably you are yet to read that note.
Yes.
Then probably we will be
Very well.
in a better position to understand and appreciate what you want.
This is a crucial question, Millard. I have to answer it. I have to, yes. Millard, let me complete this note. When I come to that note, Millard, where I have dealt with it elaborately, I will answer that. Now, Millard, page 19, paragraph 50. The plural and internally diverse character. I'm sorry, Millard.
No, you are page 192.
That's right, Millard. 188, I think. Paragraph 50.
188.
Yes. The plural and internally diverse character of Hindu religious traditions has also been recognized by this Honorable Court. This recognition that religion includes distinctive rituals, observances, and modes of worship necessarily acknowledges that different religious communities and traditions may preserve their own doctrinal and ritual disciplines. In the Hindu religious context, such traditions have historically taken the form of distinct sampradayas organized around shared theological understanding and modes of worship. Then, Millard, I refer to 394A and religious denomination, the Hindi translation, Dharmic Sampradaya, I refer to that. And then, Millard, para 52, the constitutional guarantee of denominational autonomy must therefore be understood in the civilizational context. The protection afforded by Article 26 extends to religious traditions organized through sampradayas, whose continuity depends upon the preservation of the distinctive practices, discipline, and modes of worship. Interpreting the expression religious denomination in a manner that disregards this traditional structure would overlook the historical organization of Hindu religious life that the Constitution itself seeks to protect. Then, I have referred to a passage of Justice Jagannath Reddy in Keshwananda Bharati, where he says, the underlying portion, that the Constitution will have to be interpreted and understood in the Indian context, Indian historical situation, and Indian the milieu. The seed of the Constitution is sown in a particular soil, and it is the nature and the quality of the soil and the climatic condition that prevalent there which will ensure its growth and determine the benefits which it confers on its people. We cannot plant the same seeds in a different climate and different soil and expect the same growth and same benefit therefrom. Law varies according to the requirements of time and place. Justice thus becomes a relative concept, varying from society to society according to the social milieu and economic conditions prevailing therein. Difficulty to my mind, which foreign cases or even cases decided within the Commonwealth, where the common law forms the basis of legal structure of that union, just as it is to a large extent the basis in this country, is that they are more often than not concerned with expounding and interpreting provisions of law which are not in pari materia with those we are called upon to consider. The problems which confront those courts in the background of the state of the society, the social and economic setup, the requirement of a people with a totally different ethics, philosophy, temperament, and outlook differentiate them from the problems and outlook which confront the courts in this country. Therefore, my lords have recently also stated that we have to look at our background. Therefore, we have to have an interpretation based on the Indian situation. That is, in the next page. Therefore, the conclusion is it is extremely unsafe to assume that a decision on one of them can be applied without qualification to another, that is in one jurisdiction, etc. And in Shirurmat, therefore, please now also come to, this is the holding of 7 judges. In answer to what my lords were asking me, we have to deal with this in spite of this holding in Shirurmat. How did Venkatramana Devaru take a slightly different view? The last 8 lines from the bottom, under Article 26B, therefore, a religious denominational organization enjoys complete autonomy in the matter of deciding as to what rites and ceremonies are essential according to the tenets of the religion they hold, and no outside authority has any jurisdiction to interfere with their decision in such matters. This includes not merely the judiciary, but even the legislature. And 25(2)B, that is again reiterated in the bench. I'll deal with that. Now, I have summed up the conclusion on this, in paragraph 56. Expression religious denomination occurring in 26 has been judicially interpreted by Shirurmat by reference to Oxford Dictionary meaning, which was subsequently reiterated in S.P. Mattel and later edition in the light of caution expressed in Keshwananda Bharati continued reliance on a lexicography definition drawn from a foreign linguistic and historical context, particularly where the expression has been translated in Indian languages as dharmic sampradaya, requires reconsideration so that the meaning of the constitutional text may be understood in the civilizational, religious, and social context in which the Indian constitution operates. Like then Millard on foreign jurisprudence, I have, Your Lordship may omit that, should be understood in the Indian context, not in the Abrahamic concept of organized religion. Then, Millard, I'll come to the group rights must prevail. Millard, earlier, Millard, while answering my lords, I had said this, that individual may have a different point of view, but his point of view cannot, Millard, mean be allowed to prevail in a manner that the collective's beliefs is destroyed. The religious denominations' beliefs or tenets are destroyed because the individual's right is asserted and will have to be given. Millard, that's a submission. And Millard, it's my respectful submission. Justice Chandrachud asked the wrong question and got the wrong answer, because he asked whether individual right should prevail over a group or collective religious right, and he held wrongly, in my respectful submission, that individual right can prevail over collective religious right. Now, Millard, kindly come to para 61. The constitutional recognition of the collective dimension of fundamental rights is not confined to religion alone. Constitution repeatedly protects the autonomy of communities in order to preserve their identity and institution. Articles 29 and 30, for instance, guarantee to linguistic and religious minorities the right to conserve their culture and establish and administer educational institutions of their choice. These provisions recognize that certain constitutional freedoms are realized not merely through individual, but through collective institutions sustained by communities. Then, Millard, I have extracted Nagaraj, constitutional claim of individual right under Article 16.1 and the preferential treatment given to a backward class has to be balanced. Both the claims have a particular object to be achieved. This question is of optimization of this conflicting claim, conflicting interests and claims. According to me, I will skip this para 63, 64, go to para 65. Constitutional inquiry, therefore, cannot proceed on the assumption that individual rights must invariably prevail over collective religious rights. Constitution instead contemplates a structured balance between individual freedom and denominational autonomy, within which the autonomy of religious communities in matters internal to religion occupies a constitutionally protected domain. To approach the issue solely through the prism of individual rights would risk disregarding the institutional dimension of religion that the Constitution itself expressly protects. Then I come to whether Article 25 is a horizontal right. My lords have had occasion to deal with it in the Kaushal Kishore judgment, and my Lord Justice Nagaratna in the morning referred to this. Specifically, while making a chart and listing various rights, Article 25 is not treated as a right which can be exercised horizontally. It is a right which can be exercised. Therefore, the claim against the state can lie, but not against fellow citizens. 14, etc., stands on a different footing, but 25 is not. Therefore, an individual saying that I can exercise the right against other individuals who have another kind of belief, that kind of a horizontal right is not available. That's a view. My lords have analyzed all the fundamental rights in Kaushal Kishore, and Millard take the view that this is not such a right. And Millard, what is horizontal and vertical? My lords know. I am not going to read that part of it, Millard. And then I'll go straight away to para 67.
Except in the case of habeas corpus.
I'm sorry?
Habeas corpus.
Yes, habeas. That's right.
That has been excluded by him.
That's right. Article
30.
Yes.
30.
Yeah, 30 also. Article 25 protects the individual's freedom of conscience and the right to freely profess, practice, and propagate religion against state interference, subject to public order, morality, health, and other provisions of Part 3. It does not convert disputes between private religious adherents, denominations, or groups into constitutional claims enforceable inter se. This is very important because in the morning there was a debate in regard to this. If there is a schism in the church, I have had occasion to deal with it in the context of Jacobites and Orthodox Christians. And there has been a schism running for 200 years. And as to which of them is right in terms of religious beliefs and faith is not a matter for the court, because we don't have a ecclesiastical court, we don't have a court with expertise in theology. That's not what the constitutional courts are expected to decide. Both may be right. Both are entitled to their system of faith and belief. Therefore, both pursue their independent. They have their independent churches. They have the right to practice and profess their religion, their faith. Nobody stops them from doing that. But you can't say that you have to. That's what Portuguese sought to do. My lords, in Kerala, there is a famous Coonan cross. When the Portuguese came into Kerala, they sought to convert all the Syrian Orthodox believers into Catholics. There was a huge resistance. People therefore held on to a chain. And they said, you do what you want, but we are not going to convert ourselves and become Catholics. In Ireland, when the British Crown was ruling, the Catholics, they were subjected to differential treatment. They were said, you will not have right to property. The Protestants went to the extent of saying that the Anglican Church was controlling, and the Catholics were told, you will not have the right to property. You will not have the right to succession in regard to property. This was the kind of thing that was therefore forcing them to convert. But that, of course, that's why we still have the lingering dispute between Catholics and Protestants in Ireland even today. Therefore, this is not something which the courts will enter into, courts will not decide. Each is entitled to practice and profess their own beliefs.
That's why freedom of conscience.
That's a freedom of conscience. That's a freedom of conscience. Now, I come to issue number 3. Whether the rights of religious denomination under Article 26 of the Constitution are subject to provisions of Part 3. My respectful submission on this is that 25 and 26, my lord asked whether it reforms, it's a separate island. My respectful submission is it is a distinct constitutional framework. 26 is to be dealt with separately, Millard. 26 is not subjected to other provisions of the part, nor is 25(2)(b enabling the right under 26 to be controlled. 25(2)(b is only enabling a law to be made which can regulate the right under Article 25, the individual right. Therefore, if there is no prohibition in regard to making any law for social reform. Like, for example, if somebody says that there should be a uniform civil code, it is something which can be made under Article 25(2)(a). It can be the 25(2)(a) or the first part of 25(2)(b). First part, there are 2 parts to 25(2)(b). The second is in regard to entry. 25(2)(b) first part is in regard to social welfare reform, not religious reform. And therefore, the Hindu code was brought in like that. When we had Otherwise, prior to the Hindu code coming in, even amongst Hindus, there were persons who had 3 wives, 4 wives.
No, there was no restriction.
No restriction. There was no restriction.
Came in 19.
Bigamy came to be prohibited thereafter. Well, therefore, we have to keep all this in mind when we. That is, therefore, today, if in some other religious context, if this has to be regulated, perhaps 25(2)(b) first part can be invoked. Well, it's for the legislature to decide. It's not for the court. It's for the legislature to come up with a law in regard to that. Well, my respectful submission is 25(2)(b) is expressly creates a kind of an exclusion only in regard to the individual rights under 25 and not in regard to the denominational right under 25(2). Now, Milad,
just here, when you say that 26 comes into play in relation to individual rights of 25, doesn't 25 in that respect get a horizontal projection? Because 26 is not a state right. It is a denomination right. And when a denomination right versus an individual right of conscience comes into clash, conflict, will not 25 be understood or 26 be understood as horizontal?
No, with the greatest respect, such an individual can continue to profess his own individual faith and belief. But he can't say that the religious denomination must follow mine.
Propagation.
Yes.
The word is not only practice, profess, but propagate.
Yes.
And that is where the individual's right of conscience propagation becomes eclipsed by the essential or the religious affairs managed by the denomination.
But he can't force himself.
Coming to conflict, will it not be a conflict of resolution of two fundamental rights and thereby making horizontal intrusions into each other?
An individual's fundamental right to profess, practice, and propagate religion does not mean he can forcefully assert his right.
Never saying it means that. But we mean when a conflict comes, that my degree, because everything is a matter of degree, sir,
Yes.
not in absolute terms when we come to see two rights. And when I say my right to propagate will be eclipsed by a religious affair managed by a denomination, then I have a right to challenge the religious affair.
Yes, you can.
That challenge becomes a conflict between two fundamental rights on a horizontal domain.
Milad, the question arose before my lords in the context of conversion in Reverend Stanislaus. The court took the view there can't be any forced conversion. You can propagate, you can try to persuade, nobody can stop you.
Absolutely right. That is normative. But litigation is not normative.
No, litigation,
Litigation is always
with the
contested.
greatest respect,
Someone says this is forced, someone says no, this is voluntary.
therefore,